The content you're about to hear may be graphic in nature. Listener discretion is advised. This is True Crime XS.
We're a couple of episodes in for the holidays, but this one was interesting in being tied to like a bunch of other stuff. And I don't really look at this area. This is out of Cuyahoga County up in Ohio. I don't really look at this area that much. This is the Cleveland area. But when I do, it's always like something interesting. And there's multiple people from Ohio that come up in this episode. But I wanted to like look at it from the perspective of like how weird mistaken identity can be. So today's sources are primarily the Dispatch, Cleveland.com, the National Registry of Exonerations. There's several court documents in here. And there's an Esquire piece that's like a post-release piece that I put that together when I was looking at all the materials that were available in this case. This is about a guy named Raymond Towler. Had you ever heard of him? This is a 1981 crime. Trial happens in 1981 as well. The exoneration occurs in 2010. He had been serving a life sentence. And Raymond Towler, who is the accused in this case originally, he's a black male that's 24 years old. The most serious crime here is child sex abuse, and then the additional convictions were for assault and kidnapping. The contributing factors to all of this were mistaken witness identification and false or misleading forensic evidence. And just to reiterate, this is out of Cleveland, Ohio. Cuyahoga County had it. So the crime itself is that on May 24th of 1981, an 11-year-old girl and her 12-year-old cousin, who's male, they're walking their bikes in a Cleveland park when a man in a wooded area within the park lures them over, claiming that he's found an injured deer in the trees and that he needs their help to help this deer. And as soon as he gets him out of the sight of the public, the man pulls out a gun and he assaults the boy. He makes the little boy lie on the ground and he rapes and sexually assaults this 11-year-old girl. This is one of those crimes that, first of all, it involves children. And second of all, in my opinion, this is either a stalking act or a random. Would you agree with that? Yeah, it's also kind of unusual for things like this to happen. This is the stranger danger kind of crime, don't you think?
I doubt this case was very publicized, right? As far as like what happened. I don't know about you, but it was my belief that as long as I was with somebody else, nothing was going to happen to me, right? And that this seems to kind of undo that. Because there was a boy and a girl. And I don't know if they were playing together. It
kind of does a little
bit, yeah. To be, like, I don't know the further circumstances. Obviously, they were children, so we could probably find their identities, but why would we want to do that, right? But anyway, so there's a whole lot of it to me that it seemed kind of surreal, I guess would be a good way to put it. Because, like, how on earth did this occur? When I was a kid and I walked to my friends' houses, like, we walked each other halfway because we needed to be together. And so in this case, this completely undid that.
Yeah, it does undo that. The investigation into this is a little weird. For like 3 weeks, this crime receives very little publicity except that the police are looking for someone. Roughly 3 weeks after the crime, Raymond Towler is near this same Cleveland park when he runs a stop sign in his car. So because he's run this stop sign, a park ranger here pulls him over and he notices that Raymond seems to resemble the composite sketch of the person who had attacked this 11-year-old girl and her 12-year-old cousin. This sketch arose from interviews with the children. The park ranger brings Raymond Towler into the police station. And at the police station, they take his picture. And over the course of the next couple of days, so almost a month out from these attacks, both the boy and the girl pick Raymond Towler out from a photo array. It was reported that the boy took nearly 10 minutes to pick out this photo and that the girl took almost 15 minutes to pick out the photo. There were 2 other witnesses in the park that day. They also chose Raymond Towler's photo. So based on these identifications in June of 1981, Raymond Towler is arrested and he's charged with rape, assault, and kidnapping. This case goes to trial. It's not a murder trial. There's not a lot of discovery evidence that is put on. It goes to trial, and the 2 victims come in and they testify that Raymond Towler was the person who had attacked them. Then the prosecution put on both witnesses from the park that day who they also testified, and they identified Raymond Towler as the person they had seen. One of the witnesses testified that she saw the perpetrator 3 times on the bike trail the day of the crime. He was alone the first 2 times, and the 3rd time that she saw him, he was accompanied by 2 small children. The other witness testified that he only saw the perpetrator walking by himself on the bike trail, and he had passed him by on the trail. The only physical evidence that we see at Raymond Towler's trial, it comes in from a forensic analyst who is from the Ohio Bureau of Identification and Investigation named James Worcester. So James Worcester said that he had microscopically examined a hair that had been combed from the victim. He testified that the hair appeared to be a pubic hair and was a, quote, Negro hair. Negro. The female victim was white. This analyst further testified that to a reasonable degree of scientific certainty that the hair had the same microscopic characteristics as Raymond Towler's hair. And he therefore testified that the hair, quote, could have come from the defendant. However, he also testified that hairs do not possess the sufficient number of unique individual microscopic characteristics to be positively identified as having come from a particular person to the exclusion of all others. Okay, so just right there for a second, we've gotten into forensic hair cases before. From the characteristics or the appearance of the hair, you and I both know there's no way to know specifically who it came from. You can get pretty close with the idea that like there's a particular coloring, but you're really not able to do that. Now, we do know that advanced technology today can identify DNA in a number of ways from hair. But hair fiber really evidence is kind of weird. Would you agree with that?
And, you know, like I think I've given the example before,
right.
Like if you're talking about like a dark, coarse hair, clearly that's probably not going to belong to somebody who has like fine, light hair, right? So like you could make these distinctions. However, it was used in a much more conclusive and definitive way than I think would have ever been proper. And I have no idea if the people doing it had any idea that that was the case. I'd like to think that they didn't, and they were literally just using the best that they could.
Yeah. Well, so for his part, Raymond Towler does what an innocent person will typically do, and he gets on the stand and defends himself. He testifies he didn't commit these crimes, and his defense presents multiple alibi witnesses who corroborate that Raymond Towler was at home in his home with other people when the crimes took place. So even though Towler has an alibi and there's no real physical evidence tying him to this crime, he's convicted. And the law at the time had mandatory sentencing, which required the judge to sentence him a certain way because the victim was under 13 years old. He gets life in prison. The sentence is stacked as a 12 to life sentence with 2 consecutive sentences for the crimes against the little boy that run from 12 to 40 years, but they had to happen after the other sentence. This is all in 1981. In 2003, Ohio starts allowing for DNA testing in very limited circumstances. So this is 20 years after this crime. But Raymond Towler, he fits the circumstances that there's DNA evidence, and the DNA evidence could point towards a potential specific perpetrator. In a lot of instances, that should be it. that should be how this all goes. The Innocence Project, they help him file an application for DNA testing. He gets access to the testing in 2004. Shortly thereafter, the prosecutors are asked to send the pubic hair and other evidence from the crime scene to the lab. The envelope shows up at the lab, and guess what's in it? Nothing. It's an empty envelope. So a month later, the prosecutors get together with the defense, and they say that they were mailing material that was from under the victim's fingernails. Again, this evidentiary envelope from the prosecutor arrives at the lab, and it's empty. A judge finally orders that some of the clothing worn by the victims gets sent to the lab. So the clothing is examined, and there's no semen or other bodily fluids found on the clothing, and they close out testing. In 2008, 4 years have gone by, the Columbus Dispatch runs a series on Ohio prisoners who are seeking DNA testing that could potentially prove their innocence. At first, this has nothing to do with Raymond Towler. In fact, if you go and look this up, he's a blurb that pops up July 6, 2007, and then is referenced later on. That blurb in the Columbus Dispatch is very short. It just says that he was born in June of 1957. His charges are rape, kidnapping, and felonious assault. He was convicted in Cuyahoga County on September 18, 1981, and he was sentenced to life in prison. It gives a summary, which is basically like a redo of what I just mentioned. It says Towler was convicted of assaulting a young boy and raping a young girl in Cleveland. The children were coaxed into a wooded area on May 24th, 1981 by their attacker. Both victims identified Towler. A witness who saw the children with a man also picked Towler from a lineup. A DNA test was granted, but hair and fingernail scrapings mailed to a lab were missing from their evidence envelope. Available DNA evidence were clothing and underwear. The rationale for testing was this: potentially faulty witness identification. A prior unsuccessful test of the underwear could yield results using the latest techniques. And then they point out that as far as prior convictions or criminal record, Raymond Towler had none. One of the things they did that was very interesting here is they gave us a timeline of what happens next after this is put up. And it says the Dispatch reviewed 313 cases in which an Ohio inmate sought DNA testing. They realized that only 14 instances had been granted. So the Dispatch went through and identified what they thought were the 30 best prospects, meaning journalists have looked at it and gone, we think these are the 30 best of those 313. So 10% of those cases, roughly. So the Dispatch researched each applicant's prior felony convictions. They did point out that privacy laws prevent certain types of comprehensive criminal background checks. And they identify Raymond Towler. They put this out in July of 2007. And then in February of 2008, Raymond Towler again requests DNA testing. April of 2008, the prosecutor tells the judge of their intent to proceed with the testing. September of 2008, a judge orders that evidence be sent to the DNA Diagnostic Center for examination. And that lab report finally says there is sufficient semen on the victim's underwear to obtain a DNA profile. The DNA Diagnostic Center, they warn the court that this sample going into the testing process will be used completely. There will be no sample left. On October 29, 2008, the judge orders them to proceed with the testing on the victim's underwear. November 5th of 2008, so 6 days after the tests are ordered, DNA Diagnostic Center reports that they found DNA from 2 men on this 11-year-old girl's underwear. She's not 11 in 2008, obviously, but she was at the time of the crime. The DNA is conclusively ruled out as having come from Towler, and the way they stated in court is that the DNA could not have come from Raymond Towler. So the Ohio Innocence Project, again, says that these results support Towler's claims of innocence. But prosecutors say the presence of 2 profiles indicates evidence contamination, and that the DNA could have come from someone who came into contact with the underwear before or after the attack, and they'd leave him in prison. On May 4th, 2010, so a year and a half after that ruling, new DNA tests prove that Raymond Towler was not the person who assaulted the little boy or raped the little girl. And it was expected that he would be released by May 5th, 2010. His charges get vacated when he spent 29 years of his life in prison for a crime that he didn't commit. There's a little more to this, but what did you think of this?
It's an unfortunate case. He had, I mean, what I would consider to be at least not a concocted alibi. Ultimately, I believe that they were able to, they determined that sperm cell DNA, which is consistent with a rape, exonerated him as he was excluded as being the contributor. So it wasn't just contamination, right?
Correct.
It's really unfortunate that witnesses identified him. It's really unfortunate for them. It's really unfortunate for him. I don't know if it's ever come out who it was. In the case that I'm not sure that there would be anything they could do at this point, because I'm pretty sure in
1981 statute of limitations. Is that what you're thinking?
Yeah, and I'm thinking they would have run out way before because they wouldn't have been looking for anybody at the time because he was in jail for it, right?
Right.
He probably would have stayed in jail, even though it was long past, because he was sentenced. No, he could get parole, but he hadn't, right?
He had not. Well, no, he had not gotten parole. And he had this weird sentence where like it's technically a real life sentence, but like it also has this other stuff stacked on the back of it. It reads in his Department of Corrections record that he would have had a 12 to life, meaning I think the way that the judge set it up, and this is just me, I'm speculating, so I could be wrong. It almost looks like each sentence that he had, because there's one charge with the girl and two charges for the boy, and then one so it's like rape and kidnapping for the girl, all is one thing, and then an assault and a kidnapping on the boy. It's almost like he had to serve 36 years, meaning consecutive 12, 12, 12, and then he would really be eligible for parole, like beyond that. That's kind of how it reads from a legal perspective.
It's really weird, like the whole situation going through it the way that it did, because they found sperm cell DNA that excluded him, makes it pretty clear he didn't do it, right?
Right. Because
of the statute of limitations having more than likely not been applicable to a new perpetrator. Now, some stuff has happened to change some of the laws with regard to like DNA testing and stuff like that, but I still don't think it would apply based on his exoneration in 2010 and the crime having been committed in 1981. So here's what I would be interested to know, though. Did the DNA match anybody, and did that person look like him? That's what I would want to know. I
don't know the answers to that. I know that they ruled him out conclusively, but I don't know why, and I don't know who they stuck in there kind of in place of him.
Right, and what I was saying was I'm not sure that would even come up, because I don't know they can prosecute the new perpetrator, right?
Right. Yeah.
So they're not going to do their work on it, is what I'm saying. But I would like to know, like, okay, so what caused this, right? Because without the DNA evidence, he never would have been exonerated for this. He had both victims and then like two independent witnesses identify him.
Yes.
Right. And so I wonder what it was about his case that made the newspaper interested.
Well, I think it was his lack of criminal record and the fact that DNA evidence, like they were sort of at that time, they were piggybacking off the law change in Ohio, where the statutes now allowed for DNA testing under certain circumstances. So in their reporting of those circumstances, they found cases. Like, I think they went in and went, well, how many people have benefited from this law? And they were like, well, 315 people have applied, or 313, or whatever the number was. And we've only looked at 14 of those cases. And what happened? Well, we don't know yet.
Right. And I also read somewhere, and I didn't get very far into it, but part of the reason they started their own investigation was that they weren't following like this newly enacted legislation where they had to, if they denied it, they had to give a reason, and they weren't giving reasons.
Right.
And so the journalists were trying to help bring some cohesiveness to how it was being applied. The idea is that, except for the fact that it costs money that, inmates don't have, the idea is, what's the harm in testing the DNA, right?
Correct.
The worst thing that's going to happen is it's going to just affirm what's already happened. And, when you have the technology to do that, and there's any question, especially somebody who has, he was convicted quickly.
Yeah.
In this case. But to my knowledge, he has never confessed or he's always maintained his innocence. It was just at the time in 1981, having two victims and two independent witnesses identify him, that was evidence, right?
It was, yeah.
It was convincing. And, I'm not sure it shouldn't have been convincing. The issue is like, well, if he was DNA exonerated all those years later, what was the mix-up, right? Why was he identified? That's what I would want to know, I think. That's exactly what all the new DNA laws about that time, like going into the single-digit 2000, that's exactly what they were trying to do. And I think it's interesting that it played out the way it did.
Yeah, it did. So I went back through this particular case, and I went with the idea of what you just said. Now, one thing I remembered, and it's a publication, but it's pretty short. People can go find it. It's from the Ohio State Journal of Criminal Law, and I don't remember the exact edition it is because I have clippings from it, but it's by a guy named Mark Godsey, Godsey. He has this long article that is a review of a book. Now, the book is by Jim and Nancy Petro. It's called False Justice, 8 Myths That Convict the Innocent. It's by Jim and Nancy Petro. But the article is written from the perspective of Mark Godsey, and he called it False Justice and the, quote, True Prosecutor, a memoir, a tribute, and commentary. And he writes it from the perspective of having been the director of the Ohio Innocence Project. And at the time, he was watching Jim Petro go from a prosecutor to being elected the Attorney General of Ohio. And Jim Petro was kind of known for being ahead of the curve in terms of statutes that could benefit the wrongfully convicted. I read this article. It had multiple cases that it talked about, and I wanted to look at one more. So Raymond's case is kind of short. The way that all of his wraps up is the Ohio legislators had put wrongful imprisonment compensation into state law. He was going to receive about $41,000 a year for every year of wrongful imprisonment, which would have been about $1 million, $1.1 million. He was able to file on the idea of lost wages and damages. So Raymond was a musician leading up to this. From what I understand, he was a fairly talented guy who played multiple instruments. I don't know exactly how all of it shook out, but I can tell you that they end up giving him $2.5 million in compensation from the state of Ohio, and they do it quickly. So he gets out in May of 2010, and he was 52 years old on the day of his release. By mid-2011, he gets awarded $2.5 million in compensation from Ohio, and his attorneys file a federal civil rights lawsuit that it goes on for a little while, but in 2012, they settled that for $4.7 million. So he got some level of compensation. He had an interesting thing happen in 2006 I was going to bring up as well. The state of Ohio was producing a children's CD. Have you heard about this?
Yeah, that's actually, I think, what I heard about him in passing.
So in this children's CD, inmates are performing lullabies and doing sing-alongs, and the inmates are giving parenting tips. So Towler was an accomplished musician, but he is not allowed to perform on the album because he has, 1, a conviction of a sex offense, and 2, a conviction of a crime against children. So even though he's not allowed to perform on the album, he did end up getting credited as a technical advisor and as a consultant to the different artists. But this, at one point, this was a big deal because people protested this within and outside of different organizations in Ohio. But basically, like the people that get behind things like DARE and Safe and Drug-Free Schools, depending on where you live, they're called different names, these organizations. But they protested on the basis that, like, this was a contradiction.
Well, it sort of all is, right?
Yes, it is.
I mean, putting aside the fact that he's ultimately exonerated, right? It's creepy for inmates to sing lullabies.
It is all quite
and
weird.
Give parenting tips. And, like, it's a whole weird situation. I don't know what somebody was thinking. That
Well, I don't either, but from the perspective of Mark Godsey, where I was reading this review, which is it's a cool read if you want to go find it. Again, it's False Justice and the True Prosecutor, a memoir, a tribute, and a commentary by Mark Godsey, and you can find it pretty easily on the OSU websites. This is just like a random publication where it's like part of the Journal of Criminal Law up there, and I would give you the page numbers, but there's something crazy like. That particular issue was maybe 4,000 pages, I think, if I remember correctly. And his is like from page 800 to page 900. He's got 26 pages in there that you can read. But I pulled another case that was also a contradiction from that time period that goes with what you're saying. And that's the case of Clarence Elkins. Have you ever heard of him?
No, I hadn't, but I did when...
Yeah, it's kind of connected. The two are connected together. So because Raymond's case was fascinating to me, but it's sort of, honestly, even the court documents are not very long. I coupled Clarence Elkins with him because I looked at it and I was like, is this all happening at the same period of time? And it kind of is, but it had a more satisfying conclusion to it, so I thought you would appreciate that part. The crime here occurs on June 7th, 1998. Early that morning, a woman named Judith Johnson in Barberton, Ohio, which is in Summit County, she is beaten, raped, and killed. Her 6-year-old granddaughter was staying at her home. Her granddaughter is also beaten, raped, and left for dead. But it turns out that the granddaughter, which I think she's identified at different places here. I'm just not going to use her name, but I'm just going to call her the granddaughter. The granddaughter regains consciousness in the middle of the morning, and she dials the number on one of the neighbor's phones, but the neighbor's not home. So the granddaughter ends up leaving a message saying, "Someone has killed my grandmother." She then picks herself up and she walks to a different house and she gets a ride home and the police are called. So while the police are interviewing this little girl, she tells them that the killer looked like her uncle Clarence. So Clarence is Judith Johnson's 35-year-old son-in-law, a guy named Clarence Elkins. None of the physical evidence from the scene connects Clarence Elkins to the crime. Limited DNA testing that was done showed that hairs found on Judith Johnson's body did not come from Clarence Elkins. Nevertheless, he goes on trial. And in 1999, a year later, Clarence Elkins is convicted of rape and murder, and he's sentenced to life in prison on the basis of his niece, this little girl's, identification, which, when she was called to testify, she repeated that the attacker had looked like her Uncle Clarence. 3 years after this crime, when this little girl is 9 years old, she changes her account of what had happened. And she says now she remembers that the killer had brown eyes and Uncle Clarence had blue eyes. And she said that she had been wrong when she identified Clarence Elkins. So based on this statement, Clarence Elkins' lawyers asked for a new trial. All right. So this is a white guy for murder, attempted murder, rape, and assault with the crime occurring in 1998. He's convicted in 1999. His sentence is listed on his DOC record as 55 to life. He was 35 at the time this crime occurred. The contributing factor is mistaken witness identification. And did DNA contribute to the exoneration? The answer is yes.
I don't feel like it was mistaken witness identification. And the reason I say that is a child is going to be very honest. And she never said it was Uncle Clarence.
She said it looked like Uncle Clarence.
She said that it looked like Uncle Clarence. And if it had been Uncle Clarence, she would have said it was Uncle Clarence.
Right.
You see
Oh,
the
yeah.
difference? I mean, she was 6 years old, but at the same time, the fact that they jumped on that as opposed to trying to narrow it down to somebody proximity wise that, fit the capability of that kind of crime
Yeah.
in the area. To me, it was very relevant that she said it looked like Uncle Clarence. She was making the best description that she could
Right.
without being, because she had gone through a trauma, she lost her grandmother. And it's weird to me when cases like that happen because you would think that that would be something they would immediately pick up on.
Yeah.
The fact that, she didn't say it was Uncle Clarence, but we're looking for somebody who has his same general characteristics.
Right.
And I feel like that's a really important point. And nobody was paying any attention. And of course, a 6-year-old a 6-year-old victim doesn't have the wherewithal to say, hey, you idiots, I didn't say it was Uncle Clarence. And she's trying to get justice for her grandmother and herself. And so the information she's giving, she's literally just going through the motion. And in her mind, she's doing the best she can with it, right?
Yeah.
It's really sad. The whole situation is really sad.
It is. And this is a particularly violent attack on this 6-year-old. And when you have something like that happen to a child, I'm not saying, I think I agree with you. This is not like false identification by a witness. This is just like police not understanding like what is happening. Now,
I think they were like, we'll seal this right up.
yeah, they basically did. Yeah.
It's unfortunate because somebody paying attention would have said, oh, well, clearly it's not Uncle Clarence because she just said it looked like him. And if it was somebody that she could, I just feel like a 6-year-old would have said, it was my Uncle Clarence if that were the case.
Yeah.
Not it looked like him.
Well, for Clarence Elkin's part, his wife, Melinda, believed him. He told the police that he had been drinking with friends until about 2:40 in the morning. Melinda testifies that she saw him when he came home, and she knew that he was still there because she had been up all night caring for one of their children who was sick.
Right. And so this would have been her mother.
Yeah, this is her mom. And so
was murdered. Right.
She essentially is the one who gets involved here. And I hate to say it this way, but she saves Clarence's ass. Brooke is trying to take back her testimony, so to speak. She's trying to recant.
This is later.
Right. What they discover is that the family, including the Elkinses, they have attempted to get as much information out of Brooke as possible. And one of the things that they did was they had her hypnotized. So the prosecution, when Clarence Elkin's lawyers bring up they want a new trial based on this recantation from the little girl, the prosecution says that because of this coaching, there's no way this is like real, her taking this back.
I don't feel like she's taking it back. I feel like she grew up and she realized what happened and was trying to clarify.
I think you're right. I mean, she even says in materials that you can find now, she says that the chief prosecutor at the time came to her and was like, you have to do this. And like, she only came in and talked to her because the person that was first chair on the case, a guy named Michael Carroll, he knew that this girl was the only way to get Clarence Elkin convicted.
It took her time and maturity because this is just what I imagine. I imagine this child is doing what she's been told. She's been through a traumatic event. These are the officials that are going to take care of it. I want to get justice for grandma. I want to get justice for myself. And I'm going to tell them, what I've said. And they'll figure it all out. Right?
Yeah.
She gets older. She realizes oh, Uncle Clarence went to jail for this. Well, it wasn't actually Uncle Clarence. I never said it was. I said it looked like him.
Right.
Right. And so there's this divide. And so I see what the prosecutors are saying, right? But to say that it looked like Uncle Clarence because I'm making a firm distinction here because you don't have a child giving a description except in relating it to someone she knows. Okay.
That's exactly what she's doing. Yes.
Now, that to me is actually like directly not identifying him, right? Yeah. It's actually saying that, like, while it looks like Uncle Clarence, she never says it was him. And to me, like, that is just really missed. And so it seems like the prosecution, I see what the prosecution is doing here, but, you know, to say that, like, oh, there's pressure been put on the witness now, and to go back through it and realize, oh, well, she never actually said it was him. And that's exactly what she would have done if she could have, right?
Yeah.
I see it, but at the same time, these types of things are infuriating, because to have because she lost her grandmother and she was attacked,
yes.
right? I don't feel like there's any amount of pressure in the world that could be put on a victim who's been through that would cause them to recant under, you know, false pretenses. She wasn't recanting. She was clarifying.
Yeah, I agree with you. But nevertheless, this petition for a new trial, it gets back in front of the same judge who had been there presiding over Clarence Elkins' conviction in the first place 3 years earlier. And he denies the petition for a new trial in 2002. 2 years go by, and the Ohio Innocence Project gets involved in 2004. There is multiple evidence in this case. There's a lot of biological material on the body and in the body of Judith Johnson. And there is material collected from the little girl, her underwear and her body that night. And they test traces of biological material from 3 of those locations. And it reveals that the same male DNA profile shows up in all 3 locations. So the indicator is it wasn't multiple people, it's just one dude who did this. But that DNA does not match Clarence Elkins. The prosecutors continue to deny that that's possible. And they basically say Clarence Elkins is guilty.
Why do you think that happened?
Got to double down, man.
I guess so.
Got to double down. And this is, now keep in mind what we were just talking about with Raymond Towler. This is that same time period where we've got the law has changed. So now this DNA testing, the prosecutors are basically saying, look, this is just mistakes being made at the lab. It's not possible. Like, he's guilty. So in July 2005, a new judge again denies a motion for a new trial. He rules that the original verdict was based on the little girl's identification of Clarence Elkins rather than on DNA evidence. So this new scientific evidence, had it been presented to the jury, would not have changed that outcome of him being found guilty. So the defense investigation focuses in on at this point in 2005. They focus on a neighbor who had driven the little girl home after the attack and left her on the porch waiting for someone to find her for 30 minutes instead of calling the police. They wanted to know why this woman had done that. This woman is in a common law marriage. So for people who don't understand what a common law marriage is, which I think everybody should understand it at this point, you've lived together to the point in time that the law recognizes the two of you as husband and wife, or whatever your relationship is. And this person had just recently been released from prison at the time of the attack. He had been convicted and imprisoned for assaults on other little girls. So over the next year, give or take, this guy ends up being transferred to the same prison and then on to the same cell block as Clarence Elkins. Clarence Elkins, encouraged by his wife, he collects a cigarette butt that this guy has discarded. He flattens it out and mails it to his attorneys, and they conduct DNA tests on the DNA from the saliva on the cigarette butt. That DNA matches the DNA profile obtained from the crime scene evidence. Despite this match, identifying this man, the prosecution still says no to joining anything related to Clarence Elkins' conviction being overturned and him being released. So that man is Earl Mann. Have you ever looked him up? He's got an interesting past. If you want something to do later in the day, people, Earl Mann is not great at all.
Just for this particular situation, because I wanted to see the granddaughter's not wrong.
Yeah, they do. Oh, yeah. Did you pull him up for that? Yeah, that's what I was going to tell you. His DOC, they do look similar.
Well, yeah, because that was my whole thing with the other case, right? Like, did the, whatever the DNA profile yielded, was that person similar?
Their hairline
right?
and their eyes are different, but the rest of, like, the shape of their face, and I think at the time their facial hair was similar, and there were some other things about it. I remember looking at their pictures and going, oh, yeah, I understand what that little girl was saying.
Right. She said he looked like Uncle Clarence.
Yeah, just big white guy.
And Earl Mann certainly resembles Uncle Clarence. He just wasn't him.
Right. So the police actually had like a relatively good description if they would have just gone with it from the perspective of what does Uncle Clarence look like? They would have been okay.
I don't see why they didn't do that. To me, if you're speaking with a child, if they say it looks like Uncle Clarence, they're not identifying Uncle Clarence. They would have said it was Uncle Clarence. It's very different to me. And that's just a lack of communication, in my opinion.
Yeah. Well, so at this point in time, when they match Earl Mann's DNA to the DNA from the crime scene, they then have to like dig even deeper into this case. Now, Earl Mann, for his part, he's a Florida guy who had moved up to Ohio. He had a terrible criminal record. I think he had what today would have constituted a hate crime on his record. He had been accused of various robberies, and in 2002, he had been convicted of molesting his own 3 children, who were all little girls under the age of 10.
Right. And don't you think if they had done a more thorough investigation, and this guy wouldn't have been hard to find.
Yeah.
His girlfriend or whatever, his partner, she was ultimately charged with those crimes, like as
an accessory,
being part of it. She drove the granddaughter home, right?
Yeah. Yeah. She drove the granddaughter and dropped her off on the porch where she sat and waited. Yeah.
Now, I presume, okay, I don't know, but they took the fact that she said, oh, the guy looked like Uncle Clarence, and maybe she was shy. She didn't tell the neighbor why she needed a ride home, except like that they should have asked the neighbor, why did you take this little girl home randomly?
Well, so Melinda and Clarence, having got this DNA match, they've sort of like teed up another suspect that's way more likely for this crime, even though the prosecution's not looking at it. The break in this case is weirdly a Barberton police officer, a guy named Gerard Antonucci. He brings to the attention of the prosecutor that is in hard conflict with Elkins' defense attorneys that he wrote up a statement in 1999. So this is 4 months before Clarence Elkins is convicted of the murder of Judith Johnson and the assault on her granddaughter. Antonucci had arrested Earl Mann for a robbery, completely unrelated to what was happening. But during the process of arresting him, Earl Mann was so drunk that he asked Antonucci if he was being arrested for robbing and killing Judy Johnson. So, per the police department policy at the time, Antonucci wrote it up. He wrote it up as a narrative report, and he sent it over to the detectives who were working on Judy Johnson's murder. This statement was never disclosed to the defense. It was never included in any of the evidence, which it's a Brady violation, but you never know if it's going to be something you can use or not.
Well, right, but that's like tunnel vision though, right?
Correct.
Like, why wouldn't you? Because Clarence never confessed. He never, like, he maintained his innocence. His wife, who was the daughter and aunt of the victims, she
Is on his side.
Right. She maintained the innocence, and she had like a reason for maintaining the innocence. She saw him when he came home. He hadn't killed anybody. It boggles my mind why that would be so easily discarded, because he was in a vulnerable position of being intoxicated, and he says, "Are you arresting me for the murder?" And like, why wouldn't somebody look into that?
Yeah, I mean, he wrote it up, he handed it off. That, like,
even he saw the connection, right?
Yeah, I don't know, what is that guy going to? Is Antonucci supposed to like look up their pictures and see how similar they are and understand what's happening?
No, he did what he should have done.
Yeah, so
it's the detectives that have the tunnel vision, because honestly, at that point, they're not going to do a U-turn in this case. They were, because you said it was like 4 months before his conviction.
Yeah.
I mean, it would take somebody that it wouldn't have gone this route to begin with to do a U-turn here, because once you get so far in,
you double down.
They do incredible things to maintain these ridiculous cases, right?
Yeah.
I think I've seen examples where it really gets driven off the road and they just keep going, right? And so in this case, that statement was ignored, not produced, because it would have driven them off the road. Of course, it would have driven them back into the right direction, but they chose to not go with that. And so to me, once they have gotten to the investigative phase where they're making their case against Uncle Clarence, nothing that doesn't have to do with that is going to be part of what they're investigating.
Yeah. So at this point in time, we're in 2005. We're like, he's been in jail for years. But what does happen here that's interesting is that memorandum coming up, it makes everybody take a look at it. And they go back and they interview Tanya. This is the woman who took the little girl home. And they want to get her statement. So she admits, when detectives come talk to her, that Earl Mann had come home early that morning, so after the murder, and he had deep scratches on his back. And when she tried to ask him about it, he claimed that he had been with a, quote, wild woman. So according to her, when the little girl knocked on the door, Earl became angry and told Tanya not to let her in, not to call the police, and not to talk to her. At this point, authorities began to suspect that Earl Mann had been trying to rob Judy Johnson and had killed her and attempted to kill the little girl because of this. If you go and read interviews with the wife, Melinda Elkins, she states that she suspects that Tanya may have tried to influence the little girl's identification of Clarence by pointing out the possibility that it was him. I don't know for sure, but I do see in the testimony here that Tanya says, the little girl said that Clarence was the perpetrator. So she is involved in it. I don't know to what degree. But them reinvestigating this and talking to Tanya, that's ultimately what works out in favor of Clarence Elkins being released. So the guy who wrote the book that I was talking about, he's Ohio Attorney General Jim Petro in October of 2005. He actually had no authority over the case, but he decided to hold a press conference and point it out. He doesn't do it in a negative way, but he puts a lot of pressure on the local prosecutor to dig deeper. The prosecutor goes back and they do another round of testing, even though we've identified all of this in this. And when they do this next round of testing, they are using hairs from the crime scene. These hairs from the crime scene also match Earl Mann's DNA. So now we've doubled down on it, but when we doubled down on it, we have now confirmed what we said couldn't be possible. So December 15th of 2005, the charges against Clarence Elkins are dismissed and he gets released. And he goes to town filing lawsuits, which he should have at this point, by the way. Don't you think?
Absolutely, like because they caused a lot of grief. I'm kind of zeroing in on the wife and the granddaughter niece. It caused a lot of problems, and there was so much information here that investigators could have used to put this together. And Uncle Clarence never would have been involved.
Exactly. So they settle for him being wrongfully imprisoned for a million and change, but he files a lawsuit for like just that reason. And a judge ends up ruling that Earl Mann's statement to Gerard Antonucci, that's the problem. Not disclosing that to the defense, like it basically sent the defense down a rabbit hole, not having another good suspect. But at that point in time, they would have noticed the proximity of Earl Mann living there, and they would have been able to put him together with Tanya, who had contact with this little girl right after the attack. And then Mann would have been examined, and his DNA might have, it was like right on the cusp of maybe they would have been able to identify him by DNA back then. Like,
well, they could have at least asked the little girl if it was him.
Exactly. They could have put him in a lineup and said the same thing. So he does end up settling with the Barberton police as well for $5 or $6 million.
It's a shame though, because that gives that undermines law enforcement because of just everything that was happening there.
Yeah. I mean, if it weren't for Ohio passing, I think Bill 262 is passed after this. But if it weren't for them having these protections for inmates who had DNA cases, which is always crazy to me because not every case has DNA that would help. You know what I mean?
Well, I know. Plus, it's almost always gonna be, unless something new comes up, it's almost always gonna be these older cases, right? Because it was the lack of testing something that did have DNA that gives them the right to have it tested now, right?
Yes.
And we're actually sort of, obviously, it's case specific. I'm pretty sure just about every state has one of these laws based on, retesting scientific evidence in the case of people who were convicted without it.
Correct.
And so it's always interesting to me, though, because I guess it'll come a point where there are no more of those cases, right? Whether, the defendant, the person convicted of the crime dies or like whatever, but it's because we're on this precipice of cases having underwear kept, having swabs kept, having stuff kept for whatever reason, which has always fascinated me, right? Yeah. They have stuff kept. There's a questionable conviction, and they said, hey, we've got this. You can test it. I do see where sometimes it's weird how they figure out whether they're going to do it or not. I personally think, and I know it'll get to this point. It'll get to a point where we may be there now. I don't know. It's not that expensive to do these tests, and they should just make sure, right? Yeah. Just make sure that it's the right person. It is amazing, though, that anything ever turns up. I think in this particular case, I would have much rather seen a confirmation of Earl Mann having done this later, because he should have been the suspect.
Yeah. So, all right. So Earl Mann in 2008 so you're talking 10 years after the murder of Judy Johnson. He is convicted. Basically, a plea agreement is put in place so that he can avoid the death penalty. He pleads guilty to aggravated rape and aggravated murder for Miss Johnson's death, and then for aggravated rape of the granddaughter. He wasn't charged with what was probably the precipitator crime, which is robbery, because at that time, the statute of limitations probably would have been 7 years, I think, and that would have expired. So he ends up with this agreement where he's convicted in this plea agreement. He ends up being sentenced to 55 years in prison, and he won't be eligible for parole. I looked him up for some reason, like this last week, something else I was looking at, but he's not eligible for parole until he's like 91, if he lives that long.
Yeah, he'll never get out.
Yeah, yeah. And
I don't feel like people who are convicted with DNA evidence, right?
right.
They don't ever make parole.
Well, this guy, that was a particularly brutal crime. And like he was, he's just one of those people. I've seen his story. I've seen the Earl Mann story pop up in a couple of those true crime kind of collector shows. And yeah, he's just a bad dude. Like he's not a super interesting criminal either. He's just like terrible in terms of like his personality and everything he did in his life.
Well, right. But I think this case, the reason it kind of sticks out is because you've got sort of this, I don't want to say like confession, but maybe proclamation from this attorney general, right?
Yeah. Well, that's the other thing. Like, what happens if, Melinda Elkins thinks that her husband killed her mom and doesn't, stick to this? What happens if, like, they don't pay any attention to the little girl when she's talking? You know what I mean?
The thought that Tanya influenced her, right? That's kind of weird. I don't know that happened. I do think, though, that, like, the very first thing they should have said was, like, well, why would you have taken this child home? She was at her grandmother's and you have no idea anything's happened to her grandmother. So why would you just randomly do this, right?
Yeah.
That starts the suspicion, right? And it's almost like they just overlook all of that. It's a weird thing, but I don't know. And so if she had just said, I don't know who it was, right?
Yeah.
The little girl, if the granddaughter had said, I don't know who it was, would Clarence have even been on the list?
Huh.
Right?
Yeah. He wouldn't have. He would have been too far away. They would have looked more locally.
Well, right. And that's why it's kind of like, in looking locally, it would have led them to this proximity, right?
Yeah. Across the street, basically. I mean, it's close enough the little girl could walk there.
Well, right. And
the woman took her home.
Exactly, without a word, like without calling the police, why would you take a 6-year-old home without taking her back? Like, why are you here? Grandma's killed, right?
Yeah. Yeah.
Okay, so you just take her home and leave her on the porch? What are you doing? That doesn't make any sense, right?
No, it doesn't make any sense.
It's very clear cut to me. And so if she had never said like, oh, it looked like Uncle Clarence, then like they would have had to investigate like, hey, why did you take this little girl home? Well, my partner was irritated she was here. Well, okay, let's talk to him. Hey, where were you last night, right?
Yeah, but grandma's dead. Why don't you go to grandma's house or call the police to grandma's house to see if that's real? Or if you don't believe the little girl, take her back over there and drop her off with grandma, who you think is alive.
That's what I'm saying. Like, It doesn't make any sense that they went that direction. It almost seems, to me, it seems like they had to have almost purposefully ignored some really obvious things. I guess there's something that she could have said to make it seem okay that she just drove this child home.
I don't know.
I don't either. But to me, it would be very strange that you just took a child home and you didn't investigate the circumstances of which you were doing that, as opposed to her continuing to be where she was or, getting help for the reason why she's not there anymore, which would be that her grandmother was dead, right? It's weird.
Yeah, it is a weird one. And I tied these two together and I thought they would make for a good home for the holidays episode because it was such a strange series of terrible things that had to happen to these guys for them to both end up. In one way, it's strange for them to end up convicted, but then it's also strange for them to both end up exonerated.
Well, it is, but my concern is now this is 14 years out from Clarence's case, right?
From his exoneration in 2010, you mean?
Yes, that's what I mean. I'm sorry. The case happened in 1998. Right. What I'm saying is this retesting of possible exculpatory scientific evidence, right? Because the law is just about DNA.
Correct. Yeah.
It's not opening it up to anything else. It's a pretty conclusive but high standard that they had, and the evidence has to have been there. Otherwise, you're getting into a whole different situation when you're trying to get a new trial based on something new, right? So this is evidence that was already there. It just wasn't tested because the testing wasn't being done at that time.
Correct.
Like we were talking about with the dispatch, getting involved and saying, okay, these would be the best cases to do that with, right?
Right.
So it is weird, but it also goes along with the timing of like the changes that were happening, right?
It does.
And to me, it makes me more sure that there's like more cases like this.
Yeah, it definitely makes me sure that there's more cases like this. I agree with you.
And I wonder sometimes, like, all it takes, I think in both of these cases, because I read through when I was looking at Ray Towler's case, like you had to not believe a lot of people with regard to like his
alibi
account of, because his account of where he was and like how he couldn't have done it. They had to just think everybody in his life was lying.
Yeah,
right?
Or covering for him.
Right. And, obviously they weren't. But to me, and there was the eyewitness testimony from not only the victims, and these children were attacked, but they weren't murdered, which is why you have the accounts of what happened. But you also have these other independent witnesses. And so they're similar but different. I don't know. I would like to think that they after hearing from, because there was a number of people who came into just normal contact with him, indicating he couldn't have been at the scene, right?
Right.
And once that happened, it seems like they had to discount a lot of information. And I would never say in this particular situation that like, oh, there's no way there's anybody else that looks like him.
Yeah, I mean, I'm more open-minded than that. I like to think.
I would like to think so too, but I wonder because the witness testimony is compelling if you don't have any preconceived notions about it, right?
Correct. Well, but I find myself a lot of times, like the ones I worry about are some of the other cases we covered where the evidence has been destroyed because of time or whatever else.
Those are just law. I mean, because to me, without, once somebody's been convicted, without that solid DNA evidence coming forward, it's very, very, very difficult.
Yeah.
Right. Even, there's been some blatantly obvious cases, right? Yeah. That it's hard for me to even stomach. And there's always a possibility that I'm wrong. I accept that. But a lot of times it's pretty clear that I'm not wrong. And, it is a wrongful conviction. And yeah, the evidence has been destroyed. There's never going to be a definitive overturning of the conviction or exoneration, right?
Or reconviction of the right person.
Which is exactly what I was going to say. That is one of the hardest things to sort of wrap your head around. It's awful that a defendant stays in jail for a crime they didn't commit. But it also is stomach turning that somebody got away with something.
Yeah. It is. And they're out walking around.
Yeah, and they will be, I guess. Well, they may be in jail for something else.
Special consideration was given to True Crime Excess by LabrottieCreations.com. If you have a moment in your favorite app, please go on and give us a review or a 5-star rating. It helps us get noticed in the crowd. This is True Crime XS.
The season twinkles under starry skies, and Kris Kringle's drinking cherry wine. How I wish you were here to stop
True Crime Excess is brought to you by John and Meg. It's written, produced, edited, and posted by John and Meg. You can always support True Crime Excess through patreon.com, or if you have a story you'd like them to cover, you can reach them at truecrimeaccess.com. Thank you for joining us.
This is just a reminder that we are part of the Zencastr Creator Network, and I put a link in the show notes if you guys want to check it out for your own podcasting needs. I've always enjoyed using Zencastr. Their quality is great, and we were able to join their Creator Network at kind of a key time in their history. I have enjoyed it. I've considered a lot of other places to record and a lot of other ways to put together and host and distribute our podcast. But I've stuck with Zencastr the longest. We've been with them for hundreds of episodes now. And I'm putting a link in the show notes where you can check out what they have to offer and see if it's something you would want to use.